The warning signs didn't come in a speech. They didn't come in a vote. They didn't even come in a ruling. They came in the hesitation, in the pauses between questions, in the moment when the Supreme Court of the United States seemed to realize it had walked itself into a trap of its own making. And for the first time in a long time, even some of its most reliable right-wing justices sounded uneasy. Because what was being argued in that room was not just whether Donald Trump could fire a Federal Reserve governor. What was really on trial was whether the court had finally gone too far in converting the presidency into something dangerously close to a monarchy, and whether it now lacked a clean way back. The case revolved around one person, Lisa Cook, a sitting governor of the Federal Reserve, a role deliberately designed by Congress to be insulated from presidential retaliation, precisely because the Fed controls levers that can shake the global economy. Interest rates, market confidence, inflation expectations. This insulation is not a technicality. It's a firewall. Trump's position was blunt. The president should be able to remove her for cause, not proven cause, not adjudicated cause, not cause tested in court. Just cause declared by the president himself. Say the words, and the job is gone. And suddenly, in oral argument, the justices who had spent years expanding executive power began to hear the echo of their own decisions coming back at them. You could feel the shift when Justice Kavanaugh started pressing Trump's solicitor, not angrily, not theatrically, carefully, almost nervously. What happens, he asked, if a future president takes this precedent and uses it the same way? What if the justification is paper-thin? What if it's obviously pretextual? What if it's not really about misconduct at all, but policy disagreement dressed up as cause? That question matters because everyone in that room understood the subtext. The court has spent years operating under a legal fiction that presidents act in good faith, that when they invoke national security, emergency powers, or statutory language like for cause, they are doing so honestly. That fiction collapses when the president in question has a documented history of lying at scale. This is not rhetoric. This is record. Courts, fact-checkers, bipartisan investigators, and even Trump's own former officials have cataloged thousands of false statements. The problem the justices were grappling with wasn't hypothetical abuse. It was the real-world consequence of extending trust doctrines to a man who treats truth as optional. Because if for cause doesn't require proof, then it isn't a standard. It's a magic word. And magic words are exactly how authoritarian systems hollow out legal restraints without formally repealing them. Say emergency. Say fraud, say national security, say for cause. And suddenly the guardrails vanish. That's when the court started glancing at the calendar. Midterm year, electoral volatility, and the unspoken question, what happens when the shoe is on the other foot? If a Republican president can purge independent regulators with nothing more than an accusation, then so can a Democratic president. If the Fed can be politicized, so can every independent agency. Environmental regulators, labor boards, communications commissions, the entire architecture built after the Great Depression to prevent economic collapse caused by political interference. And here's the quiet irony. The justices asking these questions are the same ones who spent years dismantling those very protections under the banner of unitary executive theory. They argued independent agencies were unconstitutional. They mocked concerns about presidential overreach. They insisted elections were the only check that mattered. Now they were being forced to confront the second-order effects of their own jurisprudence. Because once you declare the executive branch largely unreviewable, you don't get to choose who wields that power. That's the pattern Trump exposes again and again. He doesn't invent new tools. He takes existing ones and pushes them past the point polite legal culture assumed anyone would dare go. He weaponizes norms the system relied on people respecting. The solicitor arguing for Trump tried to brush off the hypotheticals. We'll deal with those cases when they arise, he said. Future problems, future courts, future presidents. That answer might have sufficed in another era. It doesn't work when the danger is already in front of you, because this wasn't an abstract debate. Trump didn't hide his motive. He attacked Lisa Cook publicly. He floated accusations on social media, mortgage discrepancies, paperwork issues from years before her appointment, claims so thin they barely deserved legal oxygen. And yet the argument was that courts shouldn't look behind them, shouldn't test them, shouldn't ask whether they were real. Just trust the president. This is where the constitutional analysis becomes existential. The separation of powers is not about efficiency. It's about distrust. The framers did not assume good faith. They assumed ambition would counter ambition, that power would check power, that no single branch would be allowed to police itself. Yet here was a Supreme Court that had, decision by decision, granted presidents broader immunity, broader discretion, and broader insulation from judicial review. Absolute immunity doctrines, emergency powers doctrines, shadow docket stays that freeze lower court rulings without full explanation, each one individually defended as narrow, together forming something else entirely. A presidency that can act first, face no immediate consequences, and rely on courts to clean up later, if ever. The justices seem to realize that when it comes to the Federal Reserve, that delay could be catastrophic. Markets don't wait for law review articles. Confidence doesn't survive ambiguity. If investors believe Fed governors serve at the pleasure of a volatile president, the entire premise of central bank independence collapses. This is why even conservative jurists have historically treated the Fed as different. Not because it's sacred, but because it's systemic. You destabilize it, and you destabilize everything. That recognition may be what ultimately saves Lisa Cook's position, but it doesn't solve the larger problem. It exposes it. Because the court's discomfort wasn't rooted in a newfound respect for democratic norms. It was rooted in fear of unintended consequences. Fear that the monster they've been feeding might turn around. You could hear it in the hypotheticals. What if a Democratic president decides climate change is an emergency and removes regulators who disagree? What if media criticism becomes grounds for dismissal? What if ideological disagreement becomes cause? The answer, legally, is simple. If you authorize Trump's theory, yes, all of that becomes possible. And that's when the mask slips, because the justices don't object to executive overreach in principle. They object to losing control over who gets to use it. That's not constitutional conservatism. That's power management. Zoom out, and this case sits alongside a disturbing pattern. The court granting Trump absolute immunity for official acts. The court using the shadow docket to pause enforcement without resolving merits. The court declining to articulate limiting principles while quietly reshaping the balance of power. In other democracies, this experiment has played out. In Brazil, the judiciary confronted an insurrectionist former president and treated him like a criminal defendant, not a king. Arrests were swift. Accountability was direct. The message was unmistakable. No one is above the law. In the United States, the Supreme Court moved in the opposite direction. It elevated presidential immunity, deferred reckoning, and trusted that norms would hold. But norms don't hold when they're exploited. This is why the Fed case matters more than it seems. It's a stress test, not just of Trump's ambitions, but of the court's ability to recognize the danger it helped create. The justices understand something they won't write explicitly. Trump is not a normal litigant. He is not a normal president. The assumption of good faith collapses in his presence, and yet their doctrine requires them to pretend otherwise. So they stall. They stay rulings. They rush cases onto emergency dockets and then complain the record is thin. They create procedural chaos and then cite it as a reason for caution. This is not judicial humility. It's institutional self-protection. They want time. Time for elections, time for political change, time to later issue condemnations once the immediate damage is done and responsibility is diffuse. But time is exactly what unchecked power exploits. If the court ultimately draws a line here, it won't be because they rediscovered constitutional virtue. It will be because they glimpsed the abyss. Because they realize that if for cause means whatever a president says it means, then no independent institution is safe, not even them. Because once you normalize the idea that accusation equals authority, the latter doesn't stop at the Fed. That's the fire spreading beneath the calm surface of legal argument. A judiciary that assumed its own doctrines would only be used responsibly is now confronting a president who treats them as weapons. This moment will not be remembered for the technical holding. It will be remembered as the moment the court hesitated, the moment it realized the rules it bent for Trump don't come with an off switch. History is unforgiving on this point. Systems don't collapse all at once. They erode, one assumption at a time, one exception at a time, until the people tasked with stopping the damage discover they've already handed away the tools. The question isn't whether Donald Trump would abuse unchecked power. He already has. The question is whether the institutions that empowered him are willing to admit their mistake before the cost becomes irreversible. When the next move happens, you'll want to understand what you're seeing. Subscribe so you're not caught off guard when it matters most.